Hear ye now, the Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business before this honorable court are admonished to draw an eye and give their attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Good morning and welcome to the second day of our new term case call. For those of you, the advocates who have not been here before, the court provides you the first few minutes of oral argument question-free. For calendar cases, that's 5 minutes. For many arguments on application, it's 2 minutes. And I encourage those of you who will be arguing this morning to go directly to the outcome determinative issues in the case. We've read your briefs. We don't need you to regurgitate or try to in 15 or 30 minutes, which you've written in 50 pages or so. So with that, we'll call the first case, Kemp versus Farm Bureau.
Good morning. Good morning. Marshall Lasser for Plaintiff Appellant Daniel Kemp. May it please the court. The first issue, did this injury arise out of the transportational function? Well, Mr. Kemp was carrying home from work his work belongings, his thermos bottle, his overnight clothes, because he's an overnight truck driver, over-the-road overnight truck driver, and his briefcase. He was transporting himself and his work belongings home from work, and in the act of taking them out, he was injured. This is precisely transportational. It is distinguished from the situation where you're using a vehicle as a storage shed. You have it up on blocks in your backyard and you're using it to store your pop bottles or whatever. He wasn't using the vehicle as a storage shed. He was using it to transport his work belongings. Also, this court has made another illustration. If you, let's say you have a car in a car show and you're getting in and out of a car in a car show on the floor of Detroit Cobo Hall, whatever. Well, that is an injury. Getting in or out of that vehicle is not from the transportational use because the vehicle is not being used for transportation. Here, this is precisely transportational. He was transporting himself and his goods to his house from work. The next issue is whether this injury was merely incidental or fortuitous. Well, in the Puttkamer case, not the Puttkamer case, in a 2014 decision of Lucas Williams, when a lady was getting into and out of her car and a branch of a tree fell on her head, fortuitously, coincidentally. Well, that's simply fortuitous or incidental. Yeah, if a meteorite strikes you as you're getting in or out of your car, or a branch falls on your head, that has nothing to do with really getting in or out of the car. It's just you happen to be in the wrong place at the wrong time. But here, Mr. Kemp was hurt because he was on his tiptoes, stretching in, twisting, and lifting his stuff out of the back seat. His own testimony says that. Dr. Kora's testimony, affidavit states that. It was the act of lifting, twisting, bending forward, standing, extending on tiptoes that caused the injury. At least there's a question of fact as to that. So it was the act of unloading which caused the injury. It was not merely incidental to the unloading. Any questions?
I have one question, counsel. How would we think about this if he left his briefcase in the car for many hours? He just didn't need it when he got home, and he went back to the car, 6 hours later to get his briefcase out because he decided he needed it then. Is it still related to the transportational function at that point?
That's not the issue we have here, but since you ask, it must be addressed. The statute does not say that the unloading must be immediately upon parking the vehicle. The legislature could have seen fit to write in the statute, unloading or unloading immediately upon the parking of the vehicle or within a reasonable time thereafter. It doesn't say that. It simply says while unloading. So yes, if he had rushed out of the vehicle to go to the bathroom, for example, and then his wife said something to him and he didn't get back till 10 minutes later, then he returned to unload, that would be covered by the statute because the statute is blank as to how soon after it's parked.
But does he need to have been rushing to get to the bathroom and it has to be 10 minutes later, or is the 6 hours that I proposed still
The statute, as it reads, would say 6 hours is fine because it's the unloading. However, let's take a different circumstance, which the defendant, appellee, said. Let's say he'd unloaded the stuff, put his property down on the driveway, which he was intending to do, went into his house to go to the bathroom, came back out. Well, too late. If he injures himself lifting it off the driveway, well, it didn't happen while you're unloading.
So you probably know where I'm going with this. So some people, like my teenagers, seem to treat their cars like storage facilities. I don't know why, but they keep,
Right.
A lot of crap in there. It's mostly crap. And they, when they get it when they need it, and I really don't understand why they keep it there instead of their room,
Right.
but they're just lazy or whatever. So assume it's not something you've just transported. It's just something you always keep in the back of your car, your, fold-up chair for your swim meets or your whatever it is.
Then it's not transportational function. That's the distinction here.
How would we draw that line? How do we know that, the camping equipment that you always keep in your trunk, because that's just a convenient place to store it, you have a small apartment.
It would be hard to speculate on a universe of facts that are not in front of us.
Well, indulge us.
Okay.
Since your case, if it's only about your case,
Right.
then it has a great deal less value. We don't do error correction typically, so
Right.
unless your case has a generalizable value that we can help us determine the next cases that come along, you're really diminishing the value of us considering
Well,
your case. So
clearly-
we're trying to figure out what the broad principles are here, not just for your case, but a lot of the cases that come behind.
Let's say, Justice Young, that you are driving to Metropolitan Airport and you've got a 45-pound suitcase in your trunk. You have a flight to New York City. You lean into your trunk, and in the pulling out of that suitcase out of your trunk, you herniate a disc. Well, that's clearly transportational.
Why so?
Pardon?
Why is it?
Because you transported not only yourself, but your suitcase to the airport. That's
Why
what
is the transportational function ended when I get to the airport parking space?
Well, because the statute provides for unloading and loading while you are loading or unloading. While you are loading or unloading. That's the precise, clear words of the statute. Once you've unloaded, it ends there. But a vehicle is designed to transport not just people, but property also. And the statute covers that.
Can I ask you, have you tried to parse the language of this provision in 3106 carefully? It seems to me that it's not entirely clear what's being said here, and there's at least two venues within this provision at which you can see a spreading out in two directions. One would follow the word with, the other alternative would follow the word while. Have you made an effort to analyze this provision carefully and determine for your own purposes where it is that this provision spreads in two directions after the word with or after the word while?
Well,
because it arguably makes a difference, because it determines whether or not the initial language direct result of physical contact applies to what follows with in each of these two directions, or whether it only follows, or whether or not it only modifies the first of those different directions, while defines the second, the second connection, but has no modification by the words direct result of physical contact.
this statute, as I see it, is the injury is a direct result of physical contact with equipment.
Is there in other words, is there essentially a little a that precedes equipment, and then a b that precedes property being lifted onto?
Correct. Correct. That's the, yes. The or, yes, you have to read the with the word or.
So the little a doesn't precede the while and then the property. It precedes the equipment and then the property.
That is correct. There are two, yes, precisely. It's with contact with A, equipment, or B, property. That's where the or serves that function.
Now, what was the direct physical contact in this case that resulted in the injury?
He was lifting, he was in physical contact with his briefcase, thermos bottle, and his overnight bag, which were apparently all tied together, physically lifting, stretching in on his tiptoes and pulling them out like that.
So you think that the language direct result of physical contact is broad enough to encompass a situation in which an individual has to align himself or he has to twist his body in some way in order to conform either with the weight of the thing being removed or the configuration of the thing being removed? It doesn't have to be an immediate contact in the sense that what's being removed falls on his foot or burns him in some respect or scratches him in some way. It's enough that his body is configured and twisted about as a result of moving the item.
Right, but yes, exactly. Let me add
the
that.
item doesn't have to cause the injury in the sense of being very hot or or nails protruding from it some way, or as I say, falling on one's foot.
Right, it is the configuration of the back seat. And by the way, he was also in physical contact. He had his left hand on the back rear of the driver's seat. He used that for leverage and balance. So he was in physical contact with equipment permanently mounted on the vehicle. That's in the facts. His left hand...
No doubt he was in physical contact, but it's whether that physical contact directly resulted in some way in the injury.
Well, there are two types of physical contact. One is the physical contact with his left hand on the back seat. The other is physical contact with the property. Yes, the physical contact with the property did, according to him, according to Dr. Corr's affidavit, that twisting, lifting motion while standing on tiptoes, which stresses the calf muscle, did cause
The
the
physical
injury.
contact with the seat caused the injury?
No, it was the physical contact. It was part of it, but the main stressor here, I mean, he used his left hand on the back of the seat for balance, so while he was leaning in...
Well, I'm just trying to, I think I understand. The statute says the injury was the direct result of physical contact with the equipment permanently mounted in the vehicle.
Right.
That's what's required. The
Or...
direct result of physical contact while the equipment was being operated or used.
or property being lifted or lowered from. Or.
So you think the pertinent portion of the language that we can leave out this middle part, and you would read it that the injury was a direct result of physical contact with property being lifted onto or lowered from the vehicle in the loading or unloading process?
I do, Your Honor, and I will also state, however, that in addition to that, yes, the answer to your question, yes, that alone is sufficient. But here we have more, because his left hand was in physical contact with the back of the front seat, and he was using that to balance his body motions as he...
But that contact with the back seat's not what you're
No, not the back
claiming.
seat, the back of the front seat.
It doesn't matter.
That contact
That's
with
not what
any
you're
seat
arguing.
in the car is not what you're claiming is the direct result of the injury.
I'm sorry.
Are you claiming that contact with the seat was the direct result of the injury?
You mean the cause of the injury?
Yes.
The statute says the injury was a direct result of physical contact with. Now, it goes on to say equipment permanently mounted on the vehicle.
Right.
While the equipment was being operated or used. Or property being lifted onto
Right.
or lowered from the vehicle in the loading or unloading process. And so I asked you want us to read out the word equipment all the way through or. That's how you prevail in this case.
That
That's
is
how we
one-
have to read the statute.
There is one way, that is one of the two ways that plaintiff can prevail. One way is, yes, there's a disjunctive, A or B, yes, and plaintiff wins if you read it that way. But if you don't read it that way and simply say it must arise out of physical contact with equipment, then he did with his left hand, using that for balance and support. While he leaned in on his tiptoes, he had physical contact with.
Don't the words direct result really undercut that when you read how he says it happened? He's essentially out of the vehicle. He's got his materials, his bag and whatever, and then he turns to put them down on the ground, and as he turns to put them down on the ground, that's when he injures himself.
But there is also the element here that he did use his grip on the front seat, or his hand for balance, so he could use
At the
that
time
for.
he was injured, was he gripping the front seat?
He was, yes, he had his hand, as I recall, the exact facts, he had his hand on for balance and holding the rear of the driver's seat. Rear of the driver's seat, because he's on the driver's side, using his left hand for balance so he wouldn't fall in as he reached in with his right hand. So it wasn't as if he was just flat feet on the ground, left hand by his side,
I'm
reaching
reading
in
his
like that.
deposition testimony. I don't read it that way, but we'll let the others decide how they would see it.
Okay, thank you very much.
Thank you.
Good morning, Your Honors. John Bursch on behalf of Farm Bureau Insurance. May it please the Court. It's not the case that the legislature, in enacting this parked vehicle exception to no-fault liability, intended to cover people pulling briefcases out of their trunk when they got to the airport, or picking their purse off the front seat, or picking up a briefcase out of the back seat over a case of beer. It's not covered. And if you would expand the statute in that way, it's going to drive up premiums. And we already, as you know, have a state with the highest auto premiums in the country. This is not what the legislature intended. In order for Mr. Kemp to overcome that policy, he's got to satisfy three things. He's got to satisfy the statute, he's got to satisfy the transportational function, and he's got to satisfy the causal relationship. And he can't get past any of those barriers. Now, I think the easiest way to resolve this case is on causal relationship. And there's lots of cases out there that guide how this is analyzed. And this really is, Chief Justice Young, an error correction case. And the easiest thing to do would just be to deny leave to appeal. But thinking about the causal relationship, what McKenzie says is that if an injury could have occurred anywhere, but just happened to occur near a vehicle, that linkage is insufficient to trigger no-fault liability.
You're not, I don't mean to interrupt you, but you're not saying it's an error correction case. You're saying even if it was an error correction case, it shouldn't be corrected, right?
Right, exactly. There were no errors. So if you're going to address this on the merits, obviously write an opinion affirming. But I don't think you even need to do that. So it could have happened anywhere, and the hypotheticals that Justice McCormick and Mr. Lasser engaged in demonstrates how this could have happened anywhere. He said, well, if the suitcase or the briefcase was still in the car and he went away for a few minutes and came back, that would be covered. But if he took it out of the vehicle and put it on the driveway first and then went inside and then came back and got it, that would not be covered. I mean, that is pure fortuity. And the Michigan Court of Appeals actually has a case that we cite in our brief on page 9. This is the Schellenberger case that directly addresses this point. There you had a truck driver, and in order to start his journey, he needed the paperwork to tell him where to go, and it was in his briefcase in a seat in the truck, and he heard himself grabbing the briefcase. Now, the facts there were much more compelling than Mr. Kemp's. The car was running, he was getting ready to go somewhere, and he actually needed the briefcase to start his transportational journey. And yet the Court of Appeals said that's still fortuitous. It's still but for. It's not proximate or anything even close to that. And the Thornton case that this court decided puts additional gloss on that. It says that the vehicle, in order to satisfy the causal relationship factor, has to be the instrumentality of the injury. And the instrumentality was him reaching...
Mr. Bush, good afternoon, or good morning.
Good morning, Justice Goodstein.
Good morning. It's always nice to have you with us. Just a few quick questions just to kind of get us started. You don't feel that your argument is kind of pushing the envelope a little bit, because we're talking about the loading and unloading process, correct? Am I correct?
You are not correct, and let's talk about that.
Hold on. Let me ask you a few questions, and then we'll build up to that. So you said I'm not correct. But in terms of, you made a policy argument in the beginning. So the question I would pose to you is that when we're talking about the traveling, isn't it customary that people travel with their items and their belongings? Like, isn't that a customary thing that if I'm going to go to the airport, I'm going to have luggage? If I'm a truck driver, I'm going to have my overnight case and my briefcase? I mean, isn't that part of the whole idea as to what's being encompassed when we talk about the loading and unloading process? Because people travel with items and possessions, and they unload and load those possessions into and out of their vehicle as part of the process of travel.
Well, two responses to that, Justice Bernstein. Now you're talking about the transportational function. And even if this was part of the transportational function, and it's not, I'm going to explain why in a second, it would still have to have that causal relationship with the vehicle. And the fact that you could hurt yourself getting your suitcase out of the trunk or off the shelf in your house or off the floor at a department store means that the vehicle is entirely a fortuity here.
But he wasn't using his truck as the purpose of a truck? As
that's a different question, whether there was a transportational. He has to satisfy both. But on the transportational point, I'm going to draw this Court's attention to a case in a very different context, but one that you just looked at past term, and that's the Yono versus MDOT case, which of course you'll remember was whether there was a vehicle or a lane for travel involving a parking lane. And there the majority said that in common parlance, we consider traveling and parking to be two different things. And so the transportational function of the car ends once it's parked. And anything that you do after that point...
That's kind of an interesting point, because you had another case recently where you convinced a number of members of the court, I think even a majority,
yes,
fairly, that the transportation, or let's see, a parked vehicle, the journey ends before the vehicle's parked, I think was the line that you had a few months ago.
I was then, this is now.
Yeah, good point. Good point. But so I bring that up. I bring that up to as a sort of frame the next question, which is why is it that we need to talk about the transportation function when we're talking about parked vehicles? If they're not,
Oh, I see. That's an excellent question. And that's raised in the amici brief about whether if you satisfy one of the statutory exceptions for no parked cars, do you even get to this analysis of transportation and causation? And you absolutely have to do that.
And some of the cases, some of the Court of Appeals judges have raised the point at various times. And
yeah,
I guess the question gets to how you read 3105 in relation to 3106 and how we think of the parked vehicle exclusion, and then these various exceptions from it. And so
here's why you need both.
What's the work that the exceptions to the exclusion do? They don't substitute for causation. They don't substitute for injury. But why shouldn't we think of them as substituting for the transportation function? If we look at, for example, Miller makes the point that generally we don't think of parked vehicles as satisfying the transportation function. And that I'm inartfully reading it. It says, injuries involving parked vehicles do not normally involve the vehicle as a motor vehicle.
Right.
We start with that principle, but then we get into the legislature said with parked vehicles under these various circumstances, there will be coverage.
Right. Here's why you have to read 3105 and 3106 as being independent requirements. Because generally there is no liability under the No Fault Act for parked cars. And now the legislature creates a narrow window for some of those. But if you don't read it in tandem with 3105, you end up with this situation. In Grand Rapids, we have a children's museum. And inside that children's museum, there is a convertible that kids can play in, parked right in the middle of the floor of the museum. And there's no question that that is a parked car. And if one of the kids alighting or embarking onto the car, that would fit a statutory exception. But no one would claim that that's something having to do with the transportational function of that automobile. It's a permanent playground fixture in that museum. And so you need to have the 3105 gateway satisfied and meet an exception in 3106. And as we were just discussing, once the car is parked, you're done. And I gave the clerk a new Court of Appeals case that just came out a few weeks ago that I discovered last night. This is the Banks versus AAA case.
Don't I have to get in and out of the car? Like, when the car is parked, like, am I supposed to just stay in the car? Like, I'm just trying to understand your argument. So when the car stops, that's it? Like, what about when people get in and out of their vehicles?
Your Honor, there's a separate statutory exception for alighting from or getting into a car, which isn't at issue here. That's not the claim that he made.
Right,
we're only talking about loading and unloading.
That's correct. And I guess my point is that I'm still confused as to how the loading and unloading is not a part of the process. It's just the process of loading and unloading.
Well, let me go back to the Banks decision that was just decided by the Court of Appeals, because it addresses that very question. There, it was a priority dispute. There was a young man, and he was unloading groceries from the trunk of a car when an envoy came around the corner and hit him, badly injured him. And the question was, the envoy driver was uninsured, so was it going to be assigned to the facility, or was it going to be the insurance company of the car that he was unloading the groceries from? And the Court of Appeals and the trial court all agreed that it had to go to the unassigned claims facility, not to the insurance company of the car, because the fact that he was unloading a bag of groceries from the car was completely incidental to the transportation function. The court said, following this court's decision, I forget the name of it now, the Headley-Hart case, that it could have been a bench that he was picking up the groceries from, and the accident would have looked exactly the same. There has to be something more, both under the transportational and the causation.
I mean, it sort of begs the question that we're here to decide, really. But should it concern us that if we look at the Model Act, quite clearly, it seems to me, loading and unloading the vehicle is something that would be covered under the Model Act.
Yeah,
although the Model Act, interestingly, combines it with the conduct having to occur while occupying, entering into, or alighting from the vehicle, which would answer Justice McCormick's original question, which seems to me to suggest that the coverage under the Model Act would be more narrow than under our Act, which which creates separate categories for those, right? The entering into or alighting, that alone is enough. The unloading or unloading, that alone is enough.
Well, let's talk about.
Suggest that we would have, not only would it be covered, but we would have even broader coverage in Michigan than under the Model Act.
But let's talk about the exact language of the loading and unloading, because it is different than the Model Act, and hopefully this will address the questions that Justice Markman had, the points that Justice Zara was making, and the question that Justice Bernstein had, all about loading and unloading.
Can I understand one other matter of definition?
And I want to pile on after that.
All right.
Well, can I ask
Justice Markman,
one question of definition? Is a car that is in park mode, but the motor's running, the driver of the car is outside the car, perhaps checking to see if there's some problems of some sort, perhaps temporarily placing in that position so he can attend to some other business, whatever. A car that's in park mode, by your definition, even if the driver's outside the vehicle, is not a parked car, is that right?
Is not a parked car? Or
I'm asking you. I'd understood your definition was that a parked car was only a parked car when it was effectively immobilized.
Correct. Yes, that's correct. Under the statute, my understanding is that if your motor is running and you're in a parked position and you get hit, then all the ordinary no-fault principles still apply. So on the statutory text, I do read this as having a little a in front of equipment and a little b in front of property. So it would read, direct result of physical contact with A, equipment permanently mounted on the vehicle, comma, while the equipment was being operated or used. And the courts have already made clear that a seat, a front seat, is not equipment mounted on the vehicle. The seats and the steering wheel and all those, the windows, those are the vehicle. For something to be mounted on the vehicle, you have to have something else while the equipment was being operated or used. So it can't just be a trailer hitch or a bumper magnet or something like that. It actually has to be equipment mounted on the vehicle that can be operated. So that's number one. B, property being lifted onto or lowered from the vehicle in the loading or unloading process. And I went to the dictionary last night for the key words in that phrase: loading, unloading, and onto. And loading means a cargo, weight, or stress placed on something. Unloading means to remove something, such as cargo, from a truck, ship, etc. And onto means to a position that is on something, such as a surface, area, or object. So when you put that in the context of equipment mounted on a vehicle that has to be operated, the plain context to me is that if you get hit by the crane mounted on the truck, you're covered. And if you're hit by the property that the crane is loading or unloading mounted on the truck, you're covered. But this doesn't cover the purse, the wallet, the suitcase, the briefcase, because that's entirely outside the context of every single word in this exception.
I'm sorry, I'm confused. It seems to me that you're reading the or to be an and then.
No.
So you have to have contact with the equipment permanently mounted on the vehicle and.
No, or.
So explain how it's an or.
Let's say that you got the crane and it's holding some large crate, and you're hit by the crate, not by the crane. You're hit by the crane or the property. Either way, you fit the statutory exception.
Because the equipment permanently mounted while being operated is the threshold
That's the
for
A.
injury.
Yeah, that's
Doesn't
the
that
A,
suggest that-
But
and the B is the
makes
property.
but that makes it an and. You have to satisfy both. You have to have contact with the equipment permanently mounted on the vehicle.
No, because if you're hit by the crate, but not by the crane,
I
you're not being
understand.
hit by the crane.
Yeah, but where does the equipment permanently mounted onto the vehicle come into play then, in your definition? I
Well,
thought,
it's two ways that you can satisfy the exception. One is if you get hit by the equipment, right? Direct result of physical contact with equipment.
Yeah.
And then reading the B, or a direct result of physical contact with property being lifted onto or lowered from. And so
but the property being lifted onto or lowered from the vehicle doesn't, if I just read it like that, if I take my little ellipses, I write Sharpie and I mark the rest out, then I don't ever get to equipment permanently mounted on the vehicle.
right, because it doesn't have to be attached to the
So I
equipment.
don't get what is the crane, I understand you get hit by the crane. I
Yes.
get that. I don't understand why the box has to be attached to the crane.
Let
in
me
order
give
to
a
hit
better
you.
hypothetical. It doesn't have to be attached to the crane.
Okay.
If the box falls off the crane, you're still covered. The key words in the B,
Why does there have to be a crane at all?
it could be a lift, it could be, I mean, really anything.
Why
but,
can't it just be the box?
It could if it's cargo being lifted onto or lowered from, right? So the key words again,
Well, it
onto.
doesn't say cargo, it says property.
It does, but we're talking about loading and unloading and lifting something onto. I don't lift my briefcase onto, and to go back to my
But
Merriam-Webster
if we go
dictionary,
back to the Model
onto.
Act that talked about loading or unloading as a concept connected with people entering the car, alighting from the car, et cetera, it seems to me that everybody at that time understood that there was broad coverage. And in fact, it was a problem area if you look at the comments under the Act, because it says in the case of loading and unloading, the term which has produced some of the most extreme interpretations in litigation and the policy forms, basic benefits are not available unless the conduct, the limitation that we don't have in Michigan, unless the conduct in loading or unloading took place while the injured person was occupying, entering into, or alighting from the vehicle. And so it's interesting because the Model Act solved that by connecting those two together, but then Michigan decided we're not that so worried about that problem, and so we're going to disaggregate those two concepts and cover both of them separately. And I'm wondering, but now you're suggesting that somehow that the result of that is even a more narrow reading than even under the Model Act.
It's because of that word onto. Like I said, under the dictionary meaning of that, a position on something, not in something. So we're not talking about putting a suitcase in a trunk. We're talking about putting cargo on the back of a flatbed truck or something else. But
What about on a seat? Onto the seat?
that still doesn't cover the loading and unloading concepts, which would be cargo. But I see my time is done, so I just want to wrap up by saying you don't need to resolve that
Just
thorny
say what?
statutory issue because this wasn't a transportational purpose. And as I said at the beginning, the easiest way to resolve this case is to say that this was merely incidental, fortuitous, or but for. Otherwise, every claim in the world, taking any piece of property out of car is covered, and the legislature did not intend that.
Thank you very much.
Thank you.
Case is submitted.
Let's talk
No, you have no
commas.
time. Thank you.
Pardon?
The case is submitted. Your time is
Oh,
up.
time's up, no rebuttal?
No time reserved.
Sorry.